Hello, friends. I'm Nikhil, back to you with another insightful session. And today we have Advocate Meghan Paul, who is alumni of CLC, and he has been a brilliant young lawyer. And we have heard a lot of him via WhatsApp case and other new channels, and a lot of judges appreciated his efforts. And in my opinion, Meghan has been one of the brightest student of CLC and of and among his batch, I think he is the only person who is achieving this much success in litigation. And so now I will invite Megan himself to begin with his introduction. And I'm very thankful to him for sparing his precious time. And I just come to know that Megan is going through a POSCO case, which must be a effort-taking case. So please, Megan, the floor is over to you. Please start.
Thank you, Nikhil, for such a vivid introduction that you have given to me. In fact, when I joined the bar exactly around 9 months back, or 8 months, I'm so sorry, 10 months back, I never thought that this much could be achieved in such a short period of time. And there was so great to learn, so much of things to learn in litigation. It is generally very trait to say, and it's a remark which I've also heard a lot of times, that डॉक्टरी करना मुश्किल होता है, प्रैक्टिस करना इजी होता है. लिटिगेशन में क्या है, लॉ में लॉ करना इजी है, लिटिगेशन की प्रैक्टिस करना बड़ा मुश्किल. तो यहाँ बहुत सारी चीजें, बहुत एक amalgamation of a lot of factors are there when somebody joins litigation, when somebody becomes a lawyer, or somebody becomes a judge or a corporate lawyer, as the case may be. But litigation does require a lot of hard work. It requires, probably at times, even may require 18 hours of your effort in a day. So there are a lot of factors which make a lawyer. Not just one, not just knowing the law, or not just knowing the fact, but there are a lot of factors beyond that. There's a lot of persuasion tactic which goes around, that you have to understand how to persuade a judge. Now, I will, before I come on to what exactly do I understand in litigation, or how do I see the courtroom skill, or the, or if I may paraphrase it and call it the art of persuasion, a very essential thing when somebody becomes a lawyer. The art of persuasion is very important. But before I come on to that, it is very important for all the viewers, whoever may be viewing this on YouTube, on Zoom, or whoever may view it later on. I'll share an experience or an understanding of mine as to what exactly is criminal jurisprudence and how can one understand the criminal law better, or can argue a matter, or can understand a matter better than what they actually do right now. I understand that the criminal jurisprudence always comes within a box. This is, let's say, this is a box. Now, the law is objective, always
Right.
comes with a circumscribed limit. Once I say that law comes within this box, then you have a certain facts which you have in your hand. Now, those facts may come within this box or may go outside this box. Once you understand this box, and once you understand where your facts may drop, whether they would go outside the box or whether they would come within the box, then you will have a better understanding how you have to bring those facts within a box or outside that. Now, I'll simplify it further. For example, let's say there's a case which involves recovery of a knife. In some of my murder cases, there is a recovery of knife. In a couple of them, there is a recovery of a firearm. Okay. Now, this recovery, according to the judgment of Pulugari Kotaya, it
Yeah.
says is a judgment of the Privy Council, which before the law was somewhat different, and after the Privy Council set our law, it became a lot different. Section 27 was read holistically. was read in a manner which the legislature wanted it to be read. So section 27 previously was that anything recovered made the whole confession admissible.
Right.
That was before the Privy Council judgment of the Pulukari Kotaya. Once the Pulukari Kotaya judgment came in, the law, which still stands, and on firm ground, there has been some development, of course, when it comes to recovery, blood stains हैं वगैरह वगैरह थोड़ा development और हुआ है उसके बाद पुलुकारी कोटैया के बाद. But the Pulukari Kotaya, the law is very cogent and very categorically described. The law as it stands today is that only the fact discovered subsequent to the confession having been made is admissible. Now, what the police officer does is, at times, they write the whole story in the confession. Okay? And they say at the end ki चाकू जी recover हुआ इसके घर के यहाँ से, या इसकी बेल्ट से, इसकी जेब से, या इसने यहाँ पे छुपा रखा था. Okay? Obviously, it made the whole confession admissible. The Supreme Court and the mandate of the Privy Council is that no, all the confession does not become admissible by recovery of a fact. The only part which is
Right.
made admissible is that knife, that knowledge that a knife has been hidden.
Right.
Not the knife. In evidence, there are three types of evidences: an oral evidence, a documentary evidence, and a material evidence. Material evidence means a material object being produced before the court. Now, that knife will be admissible as a confession before whom it was made. The police officer, let's say, police officer is
Police
prosecutor.
officer.
Okay. Let's say it was made to a sub-inspector, and of course, the investigation in a murder matter has to be taken up by an inspector, by somebody who's at the rank of an inspector. Therefore, it would be prosecutor witness 17 who will exhibit that night, that confession, that it was made in front of me and I witnessed the recovery. Okay, so there are a lot of nuances. Now, I was on the box of criminal jurisprudence. Now, 27, if somebody knows कि यार 27 क्या है, section 27 evidence का क्या कहता है, पुल्लुकारी कोटया, Navanithin Krishnan, there are a lot of judgments, Prabhu, wherein that stained clothes were recovered, but it was never a recovery under 27. The Supreme Court said it's not a recovery under 27. Somebody is saying that ये blood होती है या ये जो cloth है वो मेरा है, does not make it a recovery under 27. That is what the Supreme Court says. Now, somebody
Right.
who knows
Right.
box jurisprudence will know better where his factual matrix is falling and will make the cross-examination accordingly, or will argue on charge accordingly, will argue on final arguments accordingly, what he has to bring within the box or what he has to get out of the box, how a particular fact can be played with. So this is very, very important, which I figured out very early in my life. I may be wrong, I may be right. That's a matter for interpretation or a matter for further debate. But as far as I've seen, and I have talked about this theory of mine with a lot of session judges, a lot of senior and session judges I've talked about, and they've always liked this theory. Now, what else do we need to think? See, we all, as a lawyer, where do I start thinking from? I start thinking from where the other person has stopped.
Stops thinking. Right.
Let's
It's
say
a famous quote that lawyers start thinking where other persons, normal persons, stop thinking. Right.
Absolutely. Let's say a police officer has filed a charge sheet. The police officers are good on procedural aspect, law, but never on evidence. They don't know how to play with the evidence. It's for the lawyer to understand how to play with the evidence. One has to start thinking that what the police officer made is a wrong charge sheet. I start thinking it from there, that what he has written is there are inherent doubts, there are inherent mistakes, in the charge sheet. And therefore start thinking. From there on, I start thinking and I start finding something from nothing. That's what we lawyers do, something from nothing. So it is very important and very vital for me when I receive a charge sheet. I have 3 charge sheets right now on my table. One is a 498A charge sheet, which is the matters coming up on charge, and another also matters. Now, what will I try to find in those charge sheets? I'll understand the defense story first. Once I've read the charge sheet, I'll understand what is my defense story
Right.
and how much can I get admissible, how much of it I can use, how much of it I can elicit through the prosecution witness itself. Now I'll delve a little deep in this. The stage of a criminal trial starts from either 2 things. Either an FIR would be registered or a criminal complaint would be filed. You can go through 156.3, an application
Right.
before the magistrate, not registering an FIR, and therefore the magistrate may direct the registration of an FIR. It will start again from the FIR. Either an FIR or a criminal complaint. Now, once an FIR is registered, investigation is embarked upon by the police officers. If it's a sessions tribal, it's generally investigated by an inspector. If it's a magistrate tribal or not so serious matter, it's invested by the SI, sub-inspectors. So once an investigation has been embarked upon, the only conclusion could be a closure report or a charge sheet.
That's
A charge sheet is then filed. What is exactly a charge sheet? The charge sheet would include all the evidences collected. But there's some doubt whether that will include an evidence which is favorable to the defense or not. And if there is some evidence which is favorable to the defense and which a defense lawyer wants to get on record on the charge sheet itself, he must
right.
be in haste to bring it before the court's attention that so on and so forth evidence is there. File a bail application before a magistrate. Let's say it's triable by sessions. There's a 439
Right.
CRPC bail issue has to be made, but don't go for it. Go for a 437. Let it be non-maintainable. Let it be brought before the court. Let's say a rape matter wherein sexual intercourse took place on the basis, mutually, it was a mutual understanding. They were in a relationship and sexual intercourse took place. It was never a rape. But the girl having some sort of a tendency gets an FIR registered under rape. She says, get my medical done. Everything would be there. Okay. But then I will have to bring before the court evidences on record that, well, this is not rape because of this factor. And let's get this in the charge sheet itself. Why should I wait for the defense evidence to be led at the end of a trial? Why not get it in the charge sheet itself? So these are questions for a defense lawyer to think. The defense never sleeps. And the defense shall never sleep in any matter.
Right.
The moment lawyers sleep, the case is out of hand. The case is going for a now. So a lot of things have to be seen. Now, there is one more observation of mine. This is a fact. And there's an interpretation of that particular fact. The fact is in the charge sheet or a complaint, as the case may be. The fact is there. But the interpretation of that fact is never in the charge sheet. That is what we have to give.
Right.
That is what I do. I do nothing more than interpreting a particular fact before the court and saying, my lords, this is my interpretation. This is the interpretation. And if it's persuasive enough, the court will follow my interpretation. They will say, well, he has the right interpretation of the facts.
Right.
That is where a very good legal acumen is required. Because a fact never makes a lawyer. It's the interpretation of that particular fact which makes a lawyer. So that interpretation is what the court wants. Never wants the fact. You might see in courtrooms a lot of arguments being addressed. That, well, ye to ye hai, janab, ye to ye hai. Nahin. It's the interpretation of that fact in your case. What is its relevance? If it is relevant, what is its probative value? Okay, I'll give you an example of this. Let's say there is a statement which is a hearsay statement.
Right.
A hearsay statement.
Right.
Section 6 of the Indian Evidence Act talks about the principle of res gestae. Res gestae. Section 6. That means that even a hearsay statement can be admissible before the court if it falls within the realm of the exception. Now, it may fall within the realm of the exception. It may become admissible, but what? How much would the court consider that statement? Whether the court will completely consider that statement or not, or whether the court will not consider it at all, will not much probative value to this, or
Right.
whether the court would be doubtful to be given. So there it is generally stated that there are three types of witnesses. One who is highly reliable, one who is highly unreliable, and the other one is neither reliable nor wholly unreliable. So a lot of things have to be, it's not, I would not say or suggest it's an easy profession. It demands a lot. It demands your complete day. It would, surely. If somebody goes independent very early like me, अभी एक medical negligence का matter आ रखा था, few hours back I was in a conference with the doctor.
Right.
He's explaining medical terminologies. I'll have to study about them as well now.
Right.
So those medical terminologies people will have to read in their MBBA. Okay, I'll have to understand and I'll have to file a reply accordingly then. So a lot of factors have to be seen when somebody goes in litigation. It's not just about the facts in the law. There's an amalgamation of psychology, sociology, understanding
Right.
as to how that such things. Okay. Persuasion, according to me, I'll give a definition of persuasion as well in litigation. Persuasion, according to me, is controlling the judge without the judge understanding that he is being controlled.
Right.
Once somebody understands this tactic, and I've argued on length times for 15 hours, sometimes the arguments are addressed 30 minutes, 20 minutes ki hui. But sometimes the arguments are addressed at length. Couple of them were in murder matters, which I did. So whenever I argue, especially whenever I argue on length, I try to understand the judge's mindset. Sometimes the judges are reluctant to hear much. Sometimes the judge wants you to go according to his own way. I'll give you one example. It was a murder wherein knife was recovered on the base or from me on the basis of a confession of a co-accused. Now, a co-accused said कि X बंदे मेरे पास knife मेरी belt में. Very well, the police say, well, we have recovered the knife. The FSL was never filed till date. It has been 2 years for me behind the bar. The FSL has never been filed. So when I started arguing that matter, and a friend of mine, a senior friend of mine, asked me to argue that matter for him. So when I started the argument, learned sessions judge Mr. Dharmender Rana is a very popular judge in Delhi District Court, Patiala House.
Right.
And others, Safora Zarogar, and others, Mr. Rana has rendered judgment. Very
Yeah,
erudite judge.
right, and he have got many highlighted cases as well.
Absolutely. So Mr. Rana, and now he knows me in my face. So Mr. Rana was hearing that matter and asked me in the very beginning itself, when I started my arguments, he asked me, you may withdraw the application, file it once the FSL is filed. Very well. He stated it 2 or 3 times. I asked my senior friend, what should I do? He asked me to press it. I pressed it on length. It was an hour-long argument. And he, of course, was not inclined to grant bail that day because he had already made up his mind. Let the FSL be filed. This is a 302 matter. So
Right.
judges are reluctant to grant bail unless and until there are strong grounds. Well, knife was recovered. I was seen in the CCTV footage. At the incident having taken place, I was captured in the CCTV footage as well. That FSL was not available. So I wanted it to be before the FSL was made available. It will be very difficult for me to get it after the FSL is filed. But then these things will have to be understood. These things will have to be understood by a lawyer as to what kind of a tactic will play and will give the best result. Sometimes
Right.
one has to wait. Sometimes one has to pound upon very early in a case. I'll discuss. You want me, Nikhil, to discuss any matter, or what do you want? I'll
I
discuss a
have
couple of.
Yeah, I have list of your highlighted cases, and I want your experience on them one by one. Like I got it from your Instagram that you appeared before an anti-corruption bureau judge, and she recorded an appreciation for you for your arguments. So, what was your experience in that case?
Okay. So एक SHO साहब का मैटर था वो. It was a corruption matter. Now this is a very high profile matter. It was covered those days a few months back. This only January 2021. It was covered a lot in media that day. I'm so sorry. So a learned friend of mine asked me to argue that matter, and I persuaded him because there was narcotics law also involved in this case. So he asked me, "Ki Meghan, let's do it together." Okay, so I persuaded him on my defense ki kya sir isme best banega, and we approached the court. Then he asked me ki Meghan, aaj aap hi argue kare pura matter. So I was not well prepared with the corruption wala. Then I said, very well, sir, I'll do that. So I argued on length that day. She heard me for 25 to 30 minutes, and she was shell shocked to see a young member arguing so eloquently well that she was orally appreciating me. After my argument, she asked me, "आप कौन से college से?" I told her that I'm from Campus Law Center. तो उन्होंने कहा लगा ही था मुझे. She's a learned sessions judge, Miss Kiran Bansal, anti-corruption bureau judge, corruption judge. And the marvelous experience to argue on and expound on the law of corruption and narcotics and on the factual matrix. At that point of time, no recovery was from me. I was part of the conspiracy. That is what the prosecution stated in that case. That some narcotics was recovered. As a police officer, I had seized some narcotics. As a police officer, I'd seized some narcotics drugs, some ganja of 160, some kgs were seized. But I have only recorded in my FIR a ganja recovered for around 1 kg or so. So my sub-inspectors and my constables were seen taking some bags in and out of the police station. And I was roped in conspiracy because I was the SHO. Some things were happening in front of me. So they thought that I would have at least the knowledge due to the authority. I would have had the knowledge that something wrong is taking place in my station. Then one of the very highlighted case, or you can say a marvelous case, is the WhatsApp's privacy policy, which I believe will actually lead the path of privacy for the future. This will actually be of privacy would be described in this, either by the High Court or of course the Supreme Court. There will be a lengthy, a remarkable judgment, a landmark judgment which
And
would be coming.
yeah,
This.
right. And
So I have impugned the policy of WhatsApp on the ground that it breaches privacy, on the ground that it stores data, and when the user wants the data to be deleted, it is in the hands of WhatsApp themselves to delete or whether to keep the data.
right,
And also that it sends your data to a third party. Now, a third party has never been described in their policy. What exactly is a third party? A third party may be a terrorist organization. Who knows? God knows.
right.
So there are certain problems with this WhatsApp. And therefore, when I read it first, I thought that let's challenge it up before the Delhi High Court. And High Court was
And right,
gracious.
and yeah, and this was the case from which we come to know you. It was Seema ma'am party there, you were there, and this was the case which really inspired us. And the most amazing thing, which was inspiring, that your opponent advocate was none other than Advocate Kapil Sibal, and you were arguing in front of such a great advocate, and that must be an opportunity for all the young lawyers that in their very first few cases they are going to argue with such panels. So it's really inspiring for us, and for CLC we can proudly say, yes, we are from College of Meghan, and that's a matter of pride.
In fact, yes, so you can also vouch for his expertise and his being an alumni of Campus Law Center. I have
Right,
argued against Mr. Sybil on two. There has never been a full-length argument on this, but yes, Sybil has been generous as a senior person, as a senior member of the bar. We have learned so much from him, at least till now. Then one of the latest matter, and also the CJI having appreciated me, was a bail matter, and it was a three judge bench headed by the learned Chief Justice of India, before whom my matter was placed before. So it was a bail matter, and after my arguments, because it was my first case before the Supreme Court, and I had to inform the court that it's my first case before my lords of the Supreme Court. So when I did that, they appreciated me, and it was in fact covered by live law as well on this
definitely.
occasion.
It was circulating all over media. Live law was giving coverage of it, and it was really a matter of proud for all of us being a CLCN, that we were really feeling proud at that moment, that to a young lawyer, judges are giving such opinion which are inspiring in themselves.
Mhm. Absolutely, Nikhil. But one thing, as a young lawyer, we should never forget that we are officers of the court. We are representatives of somebody. So whenever I argue any matter, let's say I was arguing that murder case. I've argued 2, 3 murder cases till now. So whenever I argue any matter, I am not Meghan there. I am that person being
Right,
represented by a. So always I have to think that way. I am not doing it for myself. I am doing it for somebody else. I am representing. As an officer of the court, I'm representing somebody. And therefore, it is important and vital that I live the character that I'm arguing for. If I live the character that I'm arguing for, it becomes easier for me to understand the intricacies of these. And with this, I believe there is a lot to learn for all of us. And I'm also learning a lot, having argued murder matters, special cell matters, corruption matters, arguing 302, 307, 308, 376 POXO matters, and medical negligence भी है, आ गया तो. So it is always, a person will surely get the matters according to their own merit. But somebody
Right.
should have the courage. Young lawyers must have the courage to begin somewhere. Because if we start
Right.
becoming somebody and we stop thinking our own selves, nobody today teaches so much. I have had conversations with judges for hours on end. Even in courtrooms, I have had conversations with judges for 30 minutes. Now they are the ones who teach me at times. Meghan, you were doing wrong here. Learned
Right.
session judge. One day I was sitting in his courtroom, appreciated me for the murder argument which I addressed before him,
Right.
and those things wherein and gave me a piece of advice as well. That piece of advice is very vital for me. That is what will make me a lawyer for tomorrow. Those experiences, those understandings, and those getting those responses from such highly respectable people. This is what makes an experience. This is what would make a Meghan, or this is what would make a Ram Malani or a Tanveer Ahmed Mir or a Kapil.
Definitely. Right.
This, as I said, it's all about an interpretation. How do you understand the law? How do you understand the facts? And then how do you place them before the court? Or what is required to be placed before the court? And how do you get that on record? How do you elicit in cross examinations? How do you elicit from the witnesses what you need for your final argument? So a lot of factors have to come into play when it comes to arguing a criminal matter, especially on length, or arguing many criminal matters. I now got an appeal as well before the Delhi High Court. So it takes a lot of hard work. It's never a one-day task or never a two-day task. Your lawyer is not made in a day or two. It takes a
Right.
persistent effort in the courtroom. I would, of course, suggest young lawyers to sit in courtrooms rather than chirping here and there, rather than going out with somebody. One must sit in the courtroom, try and understand. If somebody else is presenting an idea, what idea is his? Can you have a better idea than his? So all of these factors are very important to understand. And with this, I think Nikhil said a lot today.
Right, and I would like to tell the audience that when I was having first WhatsApp talk with Meghan itself, and he was very articulative and very fluent at expressing his view, and that how he connected law with philosophy, science, that how broad we have to think apart from going what we read in our law school. Because when we go to real life, real courts, it's quite different. We need to be broad knowledge of all the things. Then only we can survive in this litigation field.
Thank you, Nikhil. I believe I've said then what is necessary. And I hope everyone a very happy new year and a very happy career and a very proud career that they may have in their whole life. They may make a good career themselves and make everyone proud. I wish you all good
And
luck.
definitely everyone will get inspired by this video seeing you as their just senior. achieving this much things on WhatsApp, live log, covering him, judges are giving opinion to him, judges are applauding him. So this is something all young lawyers need. They need a pause, they need courage. And you are the perfect example that how one can courage to go against the wind, how one can choose not to be junior counsel but to be on their own, to take their own charge in the field of litigation on the very earliest days. So this is something which will inspire all the viewers, all the young generation lawyers who are struggling a lot that how to start their career.
Absolutely. I hope so. I hope
and
somebody help.
and yeah, and from the day I know you from CLC that you were a very hardworking person. You were already perfect, but you were making yourself more perfect. So that's what I found in you from day of CLC, and I was damn sure that this man is going to make us proud one day, and you did.
Thank you, Nikhil. It's in fact one must just sell his own self as one of the sculptures, a Roman sculpture, somebody who makes those horses from those marbles. Somebody asked him, Ki, what do you do to these sculptures? How do they look so brilliant? So he said, the horse is already there. The horse is already in that marble. I just have to chisel it. And somebody like me or you or anybody else, we all have to chisel our own selves. All have to
Well,
find our better selves every single day. We all have to learn from our experiences. And with this, I believe I've said a lot. I hope somebody's helped. I hope somebody learns from this. Thank you, Nikhil, for having me on.
and definitely it would be inspiration for all the lawyers. And what we're recording on YouTube, it's a part of history. Even our young generations, 10 or 20 years, they will watch you and they will get inspired from you. And even it will be privilege for me that today I'm taking your interview. And I'm damn sure in future you are going to be top lawyer of this country. And I don't know that time whether I can make time to sit with you for another interview or not. So definitely this is going to be a history. We are creating a history with you. And and the most amazing thing that you will inspire others, first generation lawyers like me, that I come from a teaching background. I belong to a family of 5 person where my father, mother, grandfather, grandmother, we all belong from teaching background. So I'm very proficient on teaching. That's why I started it when I was in 8th class. I started giving tuition. In class 10, I was having my own coaching. After 12, I started teaching NDA experience. Then it sounds like it's quite inherent that I got into teaching, and that's something I want to achieve in law. But somehow it makes me scared that I'm a first generation lawyer. So how will I compete? But you are the person who inspired me. Yes, we can compete. Only what we have to do, that we have to take our own charge.
Nikhil, even I'm a first generation lawyer, but it's not very difficult, but it's not easy either. It's not impossible, I would say.
Right.
The will which will take you there. It's the will which takes everyone where they want to. That strong will, that is what is needed. With this, I believe, yes.
And okay, so just give us few tips to your juniors so that they can have some courage that what real Megan speaks to his juniors who are just in CLC, tips from senior.
Steps. I would suggest people should read a lot. Read, talk to people, be extrovert, talk to
Right.
people, know their stories. It's all about a story. When I go to the court, it's all about a story. Who has a better story? Whether the prosecutor, it's never about the truth. It's about a story. Who has a
Right.
better story?
Story.
The story is with it. It's never about the truth. In fact, that is what the truth actually is. It's never about the truth. It's about a story. So try and understand. Reading books makes you understand. Talking to people, having conversations make you articulate. And then with God's grace, you all will achieve a lot as well. God's grace. And मैं तो यहाँ पे हूँ ही. Anyone can contact me anytime they want for any help they would ever need. I will surely.
And definitely those Yeah, and those who want to help themselves, even God is there to help them. He's the person who know the things, so He's already there for all of us generation lawyers. And
Yeah.
thank you very much for sparing your precious time and having this interview with me. And this will truly inspire our juniors. And I'm very thankful to you for sparing this time and wishing you a very happy new year and very bright career.
You too, and all of the viewers who would watch this in the future, to have very marvelous career, have a very wonderful career. Wishing you all good luck, and thank you, Nikhil. Same to you. A very happy new year. Thank you, Nikhil.
Welcome again. So right now we just talk about experience of our just senior who makes us proud. So you can Instagram him, you can Facebook him, you can Google him, and his story will really inspire you. So this is how a young generation lawyer can take his own charge and can achieve infinite. This is what we can learn from Advocate Meghan. Thank you very much for watching this video and hope it was useful to you.